Hi everyone. Hi everyone. My name is Teresa Roach and I am the Farm Family and Social Affairs Chairperson for IFA. We're delighted to welcome you today. It's a great honour to have you all present, and we have a huge interest in our webinar for Fair Deal scheme tonight. I'm delighted to welcome you all here, and we think it's such an important issue amongst farming community and urban dwellers as well. The purpose of this webinar is to inform people of how the Fair Deal scheme works, the 3-year cap on farm assets, and the criteria for farm family successor. I would like to welcome Ultan Hines, our head of HSE and for Fair Deal scheme, and he's here, who has kindly agreed to present to you tonight on our Fair Deal scheme. Ultan is now going to go through the presentation and inform you of the Fair Deal scheme, and he will also give an overview of the criteria that's needed to avail of the Fair Deal, and he will give us a perspective from the HSE tonight. He just want to inform you that we will be not discussing anything related to herd numbers or basic farm payments. And we will keep this webinar to a maximum of 1 hour. And if you have any questions to go through throughout the presentation, please type them in on the chat box, and we'll also take questions at the very end if you want to put them in verbally. Okay, and we look forward to talking to you soon. And we'll just hand it over now to Ultan Hines. Thank you very much, Ultan.
Okay, Teresa, I'm not sure if anybody other than us can hear what you're saying.
Oh, how do you know?
There's messages coming through there on the chat that people can't hear.
No sound.
There's
some people can hear
one
now.
person just said there that they can't hear. Okay.
All okay. Okay, that's good. We're good to go.
Yeah. Okay.
Okay.
Okay, thanks very much, Teresa, and thank you very much for the invitation. So as Teresa said, my name is Ultan Hines from the HSE, and we look after the nursing home support scheme for the HSE. So I'm going to talk for about 35 minutes, and the intention is just to work through some of the sections. So we'll just cover these topics. What is Fair Deal? Who can apply? We look at the application process, how we complete the application form, and then we look at state support care needs assessment, ancillary state support, and specifically then the 3-year cap on farms and business assets. I will also talk very briefly on rental income and PPR net proceeds of sale. So hopefully by the time I'm finished, you'll have a far better understanding of that than we do at the beginning. Okay, so just to put it in context then, so Fair Deal is a scheme of financial support to clients who require long-term residential care. That's nursing home care. We have an annual budget of 1.25 billion, so it's a big scheme. It's run under the Nursing Home Support Scheme Act 2009, so that's a pretty large piece of legislation. It provides huge detail as to how we run the scheme. In fact, it even gives us formulas for calculating client contributions, etc. So that's a very good thing because we've got very, very clear rules, and it means that we can administer a scheme in exactly the same way all across the country, and therefore everybody gets the same entitlement. During March, we supported 23,650 clients across the nursing home sector, both public and private nursing homes. The average length of stay is 3 years. So there's one national awaiting funding list, and each week we issue that in strict chronological order. So from the time your application is approved, you'll maximum wait 4 weeks to have funding granted. So it's a co-funded scheme, and this means that both the HSE and the client makes the contribution, and that contribution is made directly to the nursing home. And we're going to spend a little bit of time talking about that client contribution and how we calculate it and what's included and what's not. The applicant chooses their nursing home. That's assuming that they can find their first choice, etc., because nursing homes are clearly in serious demand as well. But the applicant chooses the nursing home rather than the HSE, and then the money follows the resident in that you say which nursing home you're going to, and we will pay that nursing home on your behalf. Okay, so who can apply then for Fair Deal? So the applicant themselves, if they have capacity to do so. If the applicant doesn't have capacity for state support, a specified person, and that can be a spouse or partner, a child over 18, medical social worker, medical practitioner or nurse. Also, a person who's legally appointed to act on a person's behalf can make an application. So for instance, there might be an attorney under an enduring power of attorney. A decision-making representative may have been appointed or may need to be appointed in certain cases. or there may even be a committee of ward or court arrangement in place. So there is a fair deal application form, and that's what the front cover looks like. So you can get that from your local community care office or nursing home support office, and it's also available on the HSE website. And there's a lot of extra information in there as well about the fair deal process and how to fill out the application form. So it's quite a long document, and there is both the detail we need and also a lot of information to help you as you're working through why we're looking for things and what exactly we are looking for. So I suppose we do realize, you know, generally people filling out fair deal application forms, it's in many cases it's after an incident that has happened and mum or dad has fallen, or there's been an incident or whatever, and they're in hospital, and it's really looking, look, we need to look at nursing home care. And we completely appreciate it can be a very stressful time for families. It's a big decision, you know. Not everybody maybe might be happy with it. And then you're presented with a 38-page application form. So I would say to you, you know, there's a lot of information in here. The more of it you're filling in, really, I think the more you really just need to find a quiet room someplace and read through it for an hour. And I really would say that. I'm hoping it's not as bad as it looks initially. And I'm being quite honest about that because it's a big document. Of necessity, but we have a lot of information in there to help you, and that you understand the scheme and that you understand what you're applying for and what you'll get. So as I say, don't be overcome if you have to open out the form. Have a look at it, read through it in some detail, consider it. There's a lot of supports to help you do that, help you fill it out, and I'll talk about those later on as well. And obviously the application then should be forwarded to your local nursing home support office, and there's a list of those offices on the HSE website and on the application form itself. Okay, so again, just that's what it looks like inside in terms of applying. So you apply for your care needs assessment and you apply for state support. So that's the basic application that everybody would make. And again, if the person doesn't have capacity, you'll see there at Part 2B, the people who can apply, and the same as well at Part 4B who can apply over there. And again, if somebody is acting as an enduring power of attorney or as a decision-making representation order, ward of court, etc., they would need to send in the documentation that appoints them to do that with the application when they're applying on behalf of another person. Okay, so let's move on then to the financial assessment. So this really is to calculate how much the applicant pays each week. So for a single person, it's 80% of their income and 7.5% of their assets. There's a €36,000 asset disregard. So that means that if somebody has €100,000 in the bank, we don't count the first 36,000 when we're adding up their 7.5% of their assets. There are many allowable deductions. I don't have the time to go through those this evening, but again, they are on the application form and they are on the website, and that would reduce the amount of money that you would be paying. And in terms of your income then, everybody is left with 1/5 of a non-contributory old age pension. So that's a single person. So if it's a couple, and we're assuming that one person is entering care, a couple is jointly assessed. So basically, we add the assets of both people together, and then we take 40% of the joint income, 3.75% of the joint assets, and there's a 72,000 asset disregard. Again, allowable deductions, and again, there's a minimum non-contributory old age pension plus a fifth left. So as I say, a member of a couple is assessed based on a combined income and assets of the couple, and the client contribution is then calculated. So, and that's the weekly amount that the client will pay to the nursing home. And they pay that amount irrespective of the nursing home weekly cost of care. The HSE pays the remainder. So that's an important point. If you're looking at the list of nursing homes on the website, and you'll see their weekly cost of care, and some are cheaper or some are more expensive than others, all that a person needs to concern themselves is about their client contribution. The HSE pays the balance. And I suppose just to mention as well, after a client passes away who has been supported by Fair Deal, a schedule of assets will be provided to revenue, and we access that to check that the application was filled out correctly. So just to point that out as well. Okay, let's look at a few examples. So we'll take 3 examples. Okay, so I'll just take a single person first, a fairly straightforward application. So they have a state and private pension of €500 per week. They have €10,000 in the credit union, and they have a principal private residence. Their family home is worth 300,000. Okay, so the 36,000 asset disregard is available for a single person. So 80% of their income per week is €400. The 10,000 cash assets we're not counting, and we take another 26,000 off the value of the PPR. And the weekly charge at 7.5% of that is 395.19. So that person's client contribution weekly would be €795.19. Now, at the end of 3 years, the charge that's levied, the 7.5% on the principal private residence, drops off automatically. And at that point, they would then be paying 80% of their income, which would be €400. Now, we'll also talk about ancillary state support in a few minutes, and a person could apply for ASS on the value of the PPR, and the HSE would pay that for them for the period, and then it's paid back later. We'll talk about that and how it's paid and how it's claimed back later on. Okay, so now let's look at a couple. So one member of a couple is supported under Fair Deal, the other person is at home. So we add their income together. So their client's combined weekly income is €600. Their cash assets, combined savings, 80,000, family home of 300,000. So now we're now doing 40% of the combined weekly income, which is 240. It was 80% for a single person. 3.75 of the cash assets. There's 72,000 asset disregard, so we're actually only including 8,000 here. And 3.75% of the principal private residence, which is 216. So that client's weekly contribution is 462.11. And again, after 3 years, we'll stop charging on the principal private residence. That 216 will drop off, and the person will be charged 245.76 if they're still in care after that period. Okay, now this one is a little bit more complex, and we'll spend a few minutes looking at this. And what we're looking at here really is the impact of the 3-year cap on a family farm if you apply and if you're approved for that after 3 years. So again, let's look at the couple. 600,000, combined savings of 80,000, family home of 300,000, and a family farm worth 500,000. Okay, so combined income at 40% is 240, and after 3 years it'll still be 240. Cash assets 576 because of the asset disregard. The family home 216.35, and automatically after 3 years that charge will drop and they'll be paying zero. And if they apply for the 3-year cap on the family farm and they have a family successor and they're eligible and they're approved for that, once the family successor is appointed, and if it is after 3 years, the 360.58, which is charged on the family farm, will also fall away. So that person's weekly client contribution will go from €822.69 down to €245.76. So again, just to be clear, the family home, the 3-year cap happens automatically. You don't have to do anything. It just happens. It'll fall off your charge. We'll write to you and tell you that. You need to apply for the 3-year cap on family farms and businesses. And once you're eligible and once you're approved, that charge is dropped as well. So there's a significant financial benefit to people in considering to apply for that and making sure that they comply with the requirements. Okay. Okay, so let's say that you applied and that's your client contribution there. You can apply for ancillary state support, which is the nursing home loan, on both the principal residence and the farm if you wish. And the HSE will pay the 216.35 and the 360.58 once you're approved, etc., for you for the period. And we'll look at how we recoup that in a minute. But so this is what the ancillary state support is. So it's an optional benefit under the scheme. You don't have to apply for it, but you certainly can if you wish. So it's where you don't wish to pay the full amount now, and we'll use ASS to fund the amount based on the relevant assets. You can use some of the assets or all of the assets. So you could have ASS on the principal residence, but not on the farm, or the other way around, or all of them. So the loan is essentially a mortgage, and it's treated as such. So we have to establish title to the applicant's property. And then we place a charge on the property through Tal Sheeran, or formerly the PRA. And the loan is repaid to the revenue commissioners after a relevant event. And I'll explain what a relevant event is. And it's important here, there's actually a distinction in how or at what point the ASS would be paid back on a farm or a principal residence. We'll work through that in a few minutes. So if title can't be verified, and that might be where there's the life interest, right of residency, which we don't put a charge on, or estates to be administered, we can't approve ASS. So it is actually a feature. We come across it occasionally, it's actually a feature across the west of Ireland really, where a person applies for fair deal, and then they apply for ASS, and then we look at their property, and it turns out that the property, sometimes it's actually in their grandfather's name or their father's name, so the estate was never reconciled properly. The probate was never carried through. So unfortunately, that has to be done before we can approve the ancillary state support. Now, it happens in a small number of cases, but I suppose it's back again to all of us having our affairs in order as soon as we possibly can. But unfortunately, we have to wait for that probate to go through on that estate, that it's in the name of the person applying, before we can put a charge on the property. And again, if we can't verify title, unfortunately, we can't approve the loan. Okay, so to apply for the loan, then there's a secondary part of the application form, and you fill out that as well. Or if the applicant doesn't have capacity, a person who's legally appointed to do so on behalf of them. In the case of a joint owner rather than a couple, there's another section of the form that they fill out. So for instance, this would be a case where we had maybe a brother and a sister living in a property, and they owned half and half. They had 50% share each in the property. So one of those people could still get. Now, they would actually be assessed as an individual, as a single person, rather than a couple, because they're not a couple. They're just joint owners living in the same property. So a slight distinction there. We will then write to that person, and an acknowledgement and consent form will be issued to them. And that's where they sign to say that they are willing to accept ASS, and they're willing for a charge to be put on their property. So once you accept the loan, you do that, and then we will put a charge on the property, and we'll start making that payment on your behalf. And again, just in terms of ancillary state support or the 3-year cap on farms, if the applicant or the partner doesn't have capacity to understand the application, a decision-making representation order or other legal authority will be required in that case. Okay, so when is the loan repaid then? So the loan is due to be repaid when one of the following occurs, and these are called relevant events. So it's normally after the person passes away. Sometimes the property will be sold or transferred while the person is still in the nursing home. And at that point, then obviously we stop paying ASS, and ASS must be paid back to the revenue commissioners before the sale can be finalised. Bankruptcy, we've never actually come across. False misleading information, we've never come across, but it's in the Act. So when these things happen, we contact both the revenue commissioners, because they're the people who actually collect the money, and the money goes into state funds rather than back to the HSE, by the way, and also the accountable person who's dealing with the estate or dealing with the sale of the property. And in terms of paying it back, then they have 12 months to repay the loan from date of death, or 6 months from closing date of sale. Now, in respect of the principal private residence, the loan repayment can be deferred. So we have a relevant event, and we can also have a further deferral on that. So it only applies to the principal private residence loan amount. So I suppose, to put this in context, if there is a husband in a nursing home and they've applied for ancillary state support, and his wife is at home, and the husband passes away, so that's obviously a relevant event. So what we said there earlier is that the amount has to be paid within 12 months of death. So the wife in this case can apply for a further deferral, and the money won't have to be paid back, assuming she's approved, and there's no reason why she shouldn't in most cases. Once the money will only be claimed by revenue after she passes away. All right, so there's a huge protection there for the person at home in the couple. Now, there's also a group of other people as well may also apply for a further deferral, and that's a connected person. So I'm not going to go into the detail of that, but that information is on the HSE website, and it's also on the application form. So only one deferral can be granted, and as I say, at the end of that, then, so when the second person passes away, then revenue will then look to claim the money within 12 months of that. All right. Now, there isn't an interest rate as such when you take out the loan, but the consumer price index, the CPI, is applied, added to the loan amount when it's being recalculated for collection. That's the official CPI date at the date of the relevant event. And, you know, it may increase or decrease as inflation goes up or down. But again, pay back to the revenue commissioners. Okay, right. So that's fair deal application. That's ancillary state support. And now we're moving on to the 3-year cap on farms and relevant businesses, So it actually includes both family farms and family businesses, but obviously I'm just going to focus on the family farm this evening for this conversation. So again, if you're applying for this, you need to apply through part 6 of the application form, and that's what the top of it looks like there on the application form itself. So this amendment came in 2021 to the NHSS Act 2009. So it's possible now for a 3-year cap to be extended to the family farms and businesses if certain conditions are met. So the family farm must have been actively run by either the applicant, their partner, or proposed family successor, and we'll talk about what a family successor is in a minute, for at least 3 of the 5 years prior to admission to care. So if a person goes into a nursing home today, and if they have been working the farm right up to that date, they will have obviously complied with that. If their partner or spouse or husband or wife has been working it, or the person who's going to take over as a family successor, they will have complied with this. And we ask them to complete a statutory declaration, which is available on the HSE website to confirm this. So a family successor must be appointed by the HSE. So the applicant will nominate that person. And again, that's all part of section 6 of the application form. Okay. So the family successor must commit to running the farm for 6 years from the date of appointment. And again, statutory declaration to confirm this. And once we get to the point of the 3-year cap, where we will be taking off the charge for the family farm, a charge in favour of the HSE is placed on the farm before we pay the financial benefit. And it's removed when the 6 years expire and after the family successor has met those requirements. Now, we'll talk about that a little bit more in a few minutes, okay? We may also require confirmation that the family successor continues to actively work the family farm over that period of 6 years. And that's even after the client leaves care, before the end of the 6-year period. So if the requirements are not met, there will be recoupment of family benefit gained, of the financial benefit gained. So generally speaking, when you get the benefit for the 3-year cap on farms, you get that benefit and you're not paying it back later. If you use ASS, you will be paying that back later. Okay. So the only time that the 3-year cap on family farms benefits, the money you save by applying for that, the only time that that would be looked to be recouped is if you hadn't met the requirements of the 6-year family successor period. Okay, so who can be appointed a family successor then? And the number of people here were actually extended. Now, I'm not going to work through these in individual detail. They're on the NHSS application form at page 31, but there is a wide group of people within the family. And I mean, it even goes out to a child, grandchild, or great-grandchild of a first cousin. So you must be 18 years or older, and you have to be related to the person in care or their partner, one of these people here. And as I look at, I won't go through that in any more detail. The details are on page 31 of the NHSS application form and also on the HSE website under Fair Deal. Okay, so then actively running the farm, what does that mean? So we will require proof that the person is actively working, the family successor is actively working the farm. So let's say, for instance, it's the person's daughter. The proof is it's an active Department of Agriculture DAFM identifier. So somebody who's actively working the farm will already have these documents in their possession. So we worked very closely with agriculture when this amendment came in, and they said to us that, you know, if somebody is working land, they are registered with us in some shape or form. And that form then is enough for us to accept. So we're not looking for people to go and find other things. The list of acceptable identifiers and other supporting documents, they're provided on the application form again on page 33 to 34 and on the HSE website. So again, that covers everything from dairy to beef to horticulture to fisheries to forestry, market gardening. They're pretty much all there. And as I said, we worked with agriculture. They advised us on this, and we're pretty sure that anybody who is actively farming is included. If you look at that list and you're not on it, contact us and we will absolutely look at your case. To date, we haven't had anybody who wasn't on the list, but that's not to say. So we absolutely will. We will look at that. We will work with agriculture to establish, you know, how that business is being run. Okay, so we have 3-year cap. We have 6 years for family successor. Okay, and I'm going to try and explain to you, try to highlight really how these two timelines are running and the implications of when you apply. So a person comes into care on day 1. They're in care for 5 years, let's say, and they pass away after year 5. So they can apply for the 3-year cap on farms on the day they're admitted with their application, or they can apply any time up to 3 years. They won't get the financial benefit until they reach 3 years. So in terms of financial benefit, it doesn't really matter when you apply. So at 3 years, assuming you're approved, the family asset will be removed from the assessment and a charge will be placed on the asset. Okay. After year 5, the person we're talking about here passes away, and then obviously the payment stops. However, we also have to approve or appoint the family successor. Okay, so let's say we apply and we appoint the family successor as soon as possible after admission, and that person must comply for 6 years. So after year 6, then that they've done their job, and the obligation is complete, and we'll remove the charge from the family asset. Now, if you wait until year 3, or 2 years and 11 months to apply, and the family successor is appointed on 3 years, you'll get the same financial benefit. But the family successor now must work the asset for another 3 years, for another 6 years from that point. So now they're out to year 9. Now, it is completely up to individuals themselves when they want to apply. If you apply, we will process the application. Assume everything is okay, we will appoint the family successor. But I am pointing this out to you, and I suppose we certainly would recommend that if there is a sense that you will be applying for the 3-year cap on farms, that you would do that with the application form or as soon as possible afterwards, and let's get that family successor appointed. Because there's a big difference there with complying as a family successor for 6 years or 9 years from the date of admission to the nursing home. As I say, it doesn't matter in terms of the financial benefit. It will only start at 3 years, and it'll only go on for that period. But the charge won't be removed off the asset. In this case, 9 years after admission, or in this case, 6 years after admission, whenever they're appointed. Okay, so a few key points then. So as I said, the family successor must work the asset for a period of 6 years from appointment. There can be a change to the family successor in that period, and we've already had changes. And there can be a second change, actually. In fact, that happens. That's absolutely not an issue. More than one family successor can be appointed, but they must be to different sections of the farm. So again, as a simple example, let's say a farm is in two sections, and a son is appointed to one as a family successor, and a daughter is working the other half of the farm, and that's absolutely fine. But both of them can't be appointed to the same farm, and there's no limit on the number of people who can be appointed either. If the person in care passes before the 3-year cap timeline is reached, so there's no charge placed on the asset, and the family successor won't be required to complete the 6 years. So even if you're appointed on day 1 and the person passes away after 2 years and 11 months, any obligation on the family successor dies at that point as well, because you haven't got any financial benefit. So basically all bets are off at that stage. There's no further obligation. So by applying early, you're not causing yourself any trouble, or you're not putting any extra obligation on yourself, or you're not saving yourself anything down the line. So again, we'd recommend that people apply as soon as possible. If the farm is inherited by a person who is eligible to be a family successor, and it's not the original family successor, the inheritor will be entitled to apply to continue to work the asset. So let's say a person dies at year 5, and the person who's going to inherit that farm is not the family successor, because the family successor is just one of those people who's working the land. They don't have to be inheriting it. It's none of our business who inherits the farm. They just need to be working it. At that point, the other person, assuming that they are also eligible to be a family successor, can take over and close out the 6 years. So the registered owner of the land was responsible for any repayment of the 3-year cap benefit. And if you apply for 3-year cap benefit after 3 years in care, the benefit will commence from the date of appointment of the family successor and not the 3 years. So you will have lost the savings on paying 7.5% on the farm from the end of 3 years up to the point that the family successor is appointed. So again, we're saying to you that if you believe that you're going to be eligible for this and you want to avail of it, apply earlier rather than later and save yourself money. Okay, a lot on this slide, and I won't work through it all, but This is actually one of the issues that holds up applications. So if the family farm, right, and the piece that the family successor is working isn't the whole family farm, we're going to need a map to outline the pieces that are relevant for the 3-year cap. So we have to be able to identify any assets contained in the master folio which don't attract the 3-year cap. And that might be the principal private residence if it's in the original folio, a second residence, or land leased maybe not attracting the 3-year cap benefit. So for instance, if there was a piece of the farm, you know, away someplace and that was leased out to a third party, a person who's not the family successor, that wouldn't be eligible because that's not viewed as a working family farm. Now, if the land is, if there's a lease arrangement with a son or a daughter or a cousin or whatever, that is included. That is a family farm and the lease arrangement doesn't stop it. But the person who's working the land, they must be eligible to be a family successor. So that map is required when we carry out the title check, and it'll be included in our application to Taoiseach Sheridan when we're registering the charge or the lien on the applicant's folio. And again, it must be a land registry compliant map. It must be an original certified by an engineer and architect, and it must outline the assets that are omitted from the charging order. So the request for that compliant map absolutely does not mean that the folio needs to be legally split. It absolutely does not. We just need it clearly drawn out on that map in the format that Taoiseach Sheridan require. And that allows us to put a charging order accurately on the correct assets within the folio. So it'll be a partial charge rather than a full charge. Okay, I hope I've explained that now. I know it's quite technical, but as I said, it is an important requirement and it's one that slows up applications. Okay, transferred assets then. So what's the time period for assessing a transferred asset? So a transferred asset under the Nursing Home Support Scheme Act is a person's interest in an asset which has been transferred 5 years prior to or any time subsequent to the date of first NHSS application. So if a house or a farm is transferred 2 years before the Fair Deal application is put in, we are including the value of that asset as a transferred asset. So it's valued at the estimated market value at the date of the time of transfer rather than the date of application. And if a farm is transferred in the 5 years before your date of first application, the farm may still be eligible for the 3-year cap benefit if the person to whom it was transferred is eligible to be a family successor. Now, obviously, they need to apply and comply with the requirements for 6 years. But it is possible if a transferred asset if a farm is transferred or part of a farm is transferred to a person who's eligible to be a family successor, they can apply for it even though the land is transferred. And again, that specific section is dealt with on page 31 of the Fair Deal application form. Okay, we've moved away from the farms now again, just very quickly, because we got a number of queries on this. This is about renting the principal private residence, so the family home. So a person is in a nursing home, the house is free, and somebody decides to rent it. So once they meet the criteria, and that there must be under Fair Deal, the property is the principal private residence and located in the state, rental payments are made to the client or their partner, and the property is registered with the Private Residence Tenancy Board, PRTB, we will be assessing rental at 0%. So there'll be no charge on the rental income. Now, to be clear, revenue take a different view and you have to include it in your revenue returns. So that is income as far as revenue concerned. But in terms of Fair Deal, we do not assess that as income. Also, if the principal private residence is sold while the person is in long-term care, we look at the net proceeds and they will qualify for the 3-year cap as well. Now, again, if a person is in care and the house is being sold, contact the Nursing Home Support Office immediately and they will talk you through that process. I'm not going to go into that in any further detail at the moment because it is quite technical, but just so that you know it's there. Okay, further information. So the HSE website, if you click onto the HSE website and go to Fair Deal, we have a number of pages there. It includes the application form and there's a step-by-step guide for all of these sections, including a specific section on the 3-year cap on family farms and businesses. The NHSS application form, as I said, is 38 pages, but most of that is actually information beside where you're filling in the detail to support you in knowing what you should and shouldn't include, and there's a checklist at the back. So as I say, it's really important that, particularly if you're applying for ASS or you're applying for the 3-year cap on farms, that you'd actually take the time to read that application. HSE Live, there's a free phone number there, Monday to Friday, 8 to 8, and Saturdays 9 to 5. And again, they're well briefed on Fair Deal and they're able to answer some questions for you as well. Your local nursing home support office, so whatever county you're in, there'll be a nursing home support office supporting that county or maybe two counties together. And again, the details are on the application form. If there is a decision-making representation order, the court service have an excellent section on their website, as has the decision support service. Okay, so that brings me to the end of the presentation. Teresa and Claire, I'm happy to take questions.
Perfect. Thank you very much, Ultan. It was an excellent, comprehensive presentation from yourself. So there's a good few questions coming into the chat box here. So I might actually just read them out to yourself, Ultan.
Okay.
Perfect. So just one of the first ones that came in is, if a person passes before the 3 years, do you still have to pay the full 7.5% on the principal private residence?
If they pass away?
Before the 3 years.
No, if they pass away, all charges stop immediately. The charge is only for the period. So, I mean, if you're in a nursing home, if you're getting Fair Deal for a month and either you leave the nursing home or you pass away, that's the end of your charge. And there's nothing else. You don't pay anything else. Now, if you, just to be clear on this, I mean, if you only apply for state support, if you don't apply for the nursing home loan for ancillary state support, like, you pay nothing back. There's nothing to be paid back. There's only money to be paid back if you apply for the loan. All right.
Okay, perfect. As a couple, is 3.75% of the assets charged per week?
3.75, assuming that, yeah, it's half the charge for, because they're assessed jointly. So we add their assets together, and then we take half the charge that we do for an individual.
Is the percentage of the family home taken when the person dies?
So again, it's part of their weekly client contribution, and once they die, you know, we stop charging. I mean, maybe they're asking about paying back ancillary state support, so that is a relevant event. But again, if the other partner is at home in the property, they can do that further deferral, and it's only claimed back after the person at home passes away.
Is any outstanding liability or loan repayments taken into account in asset value before asset disregard calculation?
Sorry, now give me that one again.
Is any outstanding liability or loan repayments taken into account in asset value before the asset disregard calculation?
Yes. So in terms of mortgages, etc., we have a way of processing mortgages, and effectively it's the net value. I could do a few slides on it, but we'd be here for a while. But yes, the answer is yes, absolutely, yeah. Like, if there's an issue here, Claire and Teresa, look, we can provide some extra information to you. It's difficult to work through the detail of this, you know, on a call. I literally can't pull up slides here, but you know, we'll be here for the night, like. But yeah, so the answer is yes, loans are taken into account, yes.
Perfect. If the bank balance falls year on year, can the position be recomputed, say a year or 2 years down the line? Can they be reassessed?
Absolutely. So each year, then, every 12 months, you're entitled to have a financial reassessment. So let's say there's 80,000 euro in the bank today, and then you're paying some of your client contribution out of that money, and next year there's 60,000 euro in the bank. We will do a financial reassessment, and we will be charging 7.5% of 60,000 rather than 80,000. But we don't look at revaluation of assets, of property, of fixed assets. That's at date of application. But absolutely, every 12 months yet, you can request, or you need to request it, but you can request a financial reassessment.
What happens if the farm is rented out under a con-acre agreement?
So it's a simple question for us, right? Is the farm being worked by a person who's eligible to be a family successor? We don't ask what the arrangement is. So, I mean, the land could be leased, but it could be leased to a nephew. But that nephew is eligible to be a family successor, so therefore that's a family farm. So we have no requirement to understand the arrangements for payments between people once the family successor is working the asset.
Right. I have a few questions coming in. The criteria on the successor and the 3-year cap. Maybe if you just briefly go through what the 3-year cap is, and just a question that has come in: what happens if the asset has already been transferred to a successor?
Okay, so again, just at the end there, we spoke about family successor. Maybe that came in before I did that question possibly, where the family success, if the land is transferred, if it's a transferred asset, but it's transferred to a person eligible to be a family successor, they can apply to be a family successor on that asset and get the benefit of the 3-year cap on that asset as a transferred asset.
Okay. What happens if the family successor wants to sign a site over to a son or daughter during the 6 years?
It's just removed from the section that they're working on. That's designated as a family farm because it's no longer part of the family farm. So that's why we'd have a map, for instance. We need a new map in that case to remove that site from the amount of the farm that's eligible for the 3-year cap.
But they'd still be eligible for the 3-year cap, just
On the
less
remainder.
the piece of land that was.
Yeah, we'd have to remove the piece of land because it's no longer a family farm. Yeah, but yes,
And then does that
absolutely, that is
affect the
provided.
assessment?
Yes, it does. Obviously, there'll be a minor adjustment there. I mean, in terms of the site, that's relatively minor. But yeah, there would be an adjustment. Yes. But
If
it is
land is
absolutely
current,
allowable and provided for.
okay. If land is currently leased, can you still apply for the 3-year cap?
So again, depends who it's leased to. If it's leased to a person who's eligible for to be a family successor, yes. If it's leased to a third party, it's therefore not a family farm under the Act.
Just a question on another family successor question. Just if, the way you can change your family successor within the 6 years, if you change it, does that reset the 6 years for the 3-year cap?
If you change the family successor?
Yeah.
No. What happens is, so let's say, for instance, we get to 3 years with the family successor and that person says, I'm no longer able to do this, but we are going to nominate somebody else and they'll sign up in 3 months' time. So what happens is the clock stops for 3 months. And then the next 3 years is completed after the 3 months. So the total period there is over a period of 6 years and 3 months, but there's only been a family successor for 6 years in that period.
So how long does the farm need to be transferred out of your name before it's no longer taken into consideration in the assessment?
5 years from date of first application.
Just a piece on the folio numbers, just some clarification on that again, if you wouldn't mind. Just
so I think what I was talking about on the maps, if there's a farm, a family farm included in the calculation, but that won't be up to the 3-year cap on farms, not all of it will it be eligible for the 3-year cap. So for instance, a piece of land might be leased to somebody who can't be a family successor. So that's why we need that map. But you don't have to change your folios. We just need the map that's certified as required. We're not asking people to go back and re-register folios, split up the folios on the property.
perfect. And just another one that came in here is that in the case of a couple both in a nursing home and both are joint owners of the assets, what happens on the passing of one person in regard to farm assessment?
Yeah. Okay. So I gave 2 scenarios there. One was where there was a single person, and secondly where there was a couple, one person in care. If both people are in care, both will be paying a client contribution. So we'll assess them as members of a couple. So both will be paying a contribution. Now, in terms of the PPR on that and the value of the asset, the maximum they will pay is 22.5%. So there is a protection over that even. So we have cases where people are in at the same time. And then we have cases where one member of the couple comes in, passes away, and then the next member of the couple comes in. So we treat those as a joint assessment. and they're joined up as couples, they're linked as couples, and they have a protection in terms of the amount that they pay in terms of the 7.5% on the PPR, etc. around that. Again, I didn't give that example. I didn't have time to do it, to be honest. But yeah, it's we have that situation. I said there can be two scenarios, both in together or in consecutively.
Perfect. Just in here, I know it might be repeating yourself with some of the questions that you might have already covered on the slide, but just to clarify it again for some people, if the person inheriting the farm is not going the farm, what is the situation regarding eligibility for the Fair Deal scheme?
Sorry, if they're not going to work the farm, is it?
Yeah, so yeah, if the person inheriting the farm is not going to run the farm,
well, if it's
and they apply for the 3-year cap.
Okay, so let's say the 3-year cap on farms has been for 2 years, right? Has been people are getting the benefit from 2 years, and then the person passes away and somebody else inherits the farm and say, I'm going to sell the farm. Okay, they're not going to continue to work it, or they're not eligible to be a family successor, whichever, that's fine. At that point, then they won't have met the requirements for the 6 years for that person. So therefore, we will be looking to recoup the financial benefit that they got. So the family successor must work the asset for 6 years from appointment. And if they don't, that is a recoupment event for us in terms of the benefit they got.
Perfect. So just a question
then,
who values the...
Yeah, sorry, Claire, it's actually really
Sorry,
important that it's understood in fairness. Like the family successor must work for 6 years, or else revenue will be looking for that money back, the benefit of getting it. So that is the commitment. And again, it's laid out in detail on the application form. And again, there are statutory declarations that are signed, just that people are absolutely clear, on the obligations. And I suppose in fairness, Teresa and Claire, I have to be fair to people as well and be very clear what the requirements are and what happens in certain circumstances,
Yeah. So who values the farm, just down to HSE, or do you get the farm valued yourself?
So applicants provide a valuation. The HSE has a right to seek a second valuation if we're not happy with it. It wouldn't happen in very, very many cases. Generally, auctioneers and valuers are really used to doing fair deal applicant valuations, and
There's just a few questions coming in here. I'm trying to read them here.
See, somebody there is asking
if the assets are...
Sorry, go on.
Sorry. If the assets are valued more than the cost of the nursing home, will the 7.5% per year of the full value of the farm be taken into consideration?
So, I mean, if we do a client contribution figure, right, and let's say there's just a really, really wealthy person, and that figure is €5,000. So we're saying that's what the calculation says you're paying. But nobody's paying €5,000. So they just don't get any support from the scheme. They just pay privately the rate of the nursing home. I think that I see the question here. The assets are valued more than the cost of the nursing home. Then you're not in fair deal. So therefore, you owe us nothing. We owe you nothing, essentially. I mean, you're just not in the scheme. So therefore, there's no implications or no consequence for you in terms of your assets. You're just paying privately yourself. So a small number of nursing home residents either apply for fair deal and then don't avail of it because their client contribution or whatever reason, or they just pay privately themselves. You don't have to apply for fair deal to enter a nursing home, but you do have to pay the weekly cost of care. And either we pay a contribution towards that, or you pay it all yourself.
If a person agrees to go into a nursing home, but there's a query around their capacity and, applying for the ancillary support loan, does a DMR need to be appointed?
If the person is unable to understand the terms of the scheme and sign the documentation, yes, a DMRO will be required. Now, I mean, a person may not be able to fill out the fair deal application form, but they absolutely may be able to say, yes, I understand what's happening. I understand that I'm applying for fair deal. I'm applying for this loan. and that it'll have to be paid back, and I'm signing the form. But like that might be the full extent of their involvement. Their son, daughter, whoever may be doing all the work for them in terms of filling it out, but they have made a decision to apply and decide the form. Now, if they're unable to understand the terms of the scheme, in that case, yes, a decision-making representation order would be required for ancillary state support or for the application for the 3-year cap on farms. Yeah.
If the person has a medical card, do they still have to pay towards it?
Yes, they do.
If they just in relation to the 3-year cap again, the family successor that they qualify for the 3-year cap, and the person in care dies before the 6 years, what happens to the 3-year cap then?
Have I just had I explained that one?
Maybe just when the person dies within care and there's a 6-year. The person that is the successor of the farm, do they have to still farm it for the 6 years?
They still have to farm it for the 6 years, yes.
Yeah.
And that's why we're saying about appointing the family successor as soon as possible. It's in your interest to get that person appointed as soon as possible, because the 6 years run from their date of application or their date of appointment. Once, of course, you've got the financial benefit. If the person in the nursing home passes away after 2 years and 9 months, they haven't got the benefit of the 3-year cap. So therefore, the family successor just walks away. All bets are off. It's not. They have no further obligation.
Perfect. And how do you require bank statements or proof of cash assets?
Yeah. So again, the application form works through what's required there to support the figures. And yeah, so bank statements will be required, and any other statements, etc. People with shares, etc. There's standard statements that are required there. Again, financial institutions are really, really used to dealing with fair deal applications, so it wouldn't be a surprise for them to get a request for evaluation, etc. for those statements. But yeah, but the application form will work through what's actually required as supporting documentation.
If a couple has public service pensions and inherited a farm during the course of passage of time, how would one manage the fair deal then?
Well, I mean, in terms of the 3-year cap on farms, again, it's irrelevant to us what pensions they have, how they got the farm. If it's their farm and they're working it as a family farm and there is a family successor, they'll get the benefit. If it's not being worked as a family farm, they won't. So we have a very much a hands-off arrangement in terms of, many of the ownership issues and arrangements between families. The person is either eligible to be a family successor or they're not. And if they are, they come forward and say they're working and they demonstrate that to us, and then you get the benefit.
And if the farm is not in the family successor's name, they have been actively working on the farm for 5 years.
Yeah,
what happens then?
Yeah, either the applicant, their partner, or the family successor, if once they've been working the land for 3 of the previous 5 years, they're eligible. Obviously, the family successor has to continue to work it for another 6 years, because we would only be appointing them at that point. But yeah, they're covered in that case. Yes, absolutely.
Perfect. The farm machinery then, is that included as an asset in the evaluation?
So it's farm accounts really. It's the value of the farm, and farm machinery normally wouldn't be covered. I mean, it's a depreciating asset, so it normally wouldn't be covered in our valuation. Now, unless there was something exceptional, again, we really need to see an application before we can make a decision. But generally speaking, no. I mean, it's the value of the farm and the farm accounts.
And then if farming is part of a partnership, is there any different criteria there?
So again, it's the ownership of the land. If there are two individuals who are not partners, and if they own a farm, 50% of the farm, we are assessing the 50% value of the person who's in fair deal. Now, obviously, if the partnership is between a husband and a wife, they're jointly assessed. But let's say there's 2 cousins who own 50% of a farm each, and one of them is in fair deal, we're assessing 50% of the value of the farm, because that's the amount that person owns. Again, it depends. Partnership means many things. So again, I need to see what exactly that question is, but generally that's how it's treated.
Perfect. And just another one, just following on from the machinery, is livestock still classed as the same thing? It's considered as an asset the same way as the machinery is?
Yeah, it's treated according. Again, look, generally speaking, yeah, again, livestock is coming in and out, has been sold and purchased all over the place. So it's your income, your farm income, and the value of the property.
After 1 year, the person is in the nursing home. Is the income from the farm still included in the reassessment?
I mean, if the income is theirs, yes. If it's their farm, it's their income.
I think we've covered majority of the questions. I tried to group them as best I can, so we're not repeating ourselves.
See, there's one there on siblings jointly owning. So again, just to reiterate that, if there's a brother and a sister in the house, and I'm just trying to bring it down to very practical examples now, if you don't mind, but if there's a brother and a sister in the house and they own the house 50% each, and the brother goes into care, he's assessed at 80% of his income and 7.5% of the value of the asset. But we're only doing 7.5% on half the value of the house because he owns half of it. All right. So the half of the house that's owned by his sister is not included in the valuation. Slight distinction there. Important one, but distinction between how we do couples and people, property that's jointly owned outside of a couple.
Just one there. Can the ancillary support loan be repaid in one lump sum 12 months after the 3 years?
You can do a voluntary repayment at any stage, yes. And again, if you apply for ancillary state support and after a week, a month, a year, you decide, I don't want this anymore, you tell us we'll stop paying it, and then you just pay that amount yourself. So you can apply for ASS, be approved for it, and decide, I don't want it. You can take it for a period of time and stop it, or you can continue for the period you wish. That choice is yours entirely. We would say that if people think that they will need ASS, they should apply for it when they're applying for state support, and let us get the paperwork done and let get sorted. If you don't want it, that's fine. It's no problem. But there is no issue. We'll offer it to you, assuming you're eligible, and then you might decide, you know what, not going to take it. I'll fund this some other way. That's entirely up to yourself, but you're keeping your options open.
How does one prove that you've been actively working the farm in the previous 5 years?
You'll have something from the Department of Agriculture to show that you are registered or receiving something or other. That list is on the application form and the website. So as I say, we are purposely piggybacking on documentation that you already have from agriculture.
And just would you advise to get some legal advice on going through the Fair Deal application?
I can't provide advice on that to anybody. I mean, I think I think the more assets you have, the more complex the application will be. But we certainly don't require people to seek legal advice. And however, I mean, if people believe they need it, they probably should. Again, if there's complicated assets, I mean, we deal with, I suppose, about 2 or 3% of applications are what we call ultra complex. And they would include maybe multiple assets. They could include, for instance, trust funds. Now, again, there's different types of trust funds are treated differently. We need to see the documentation. There's all types of different types of shares, for instance, and different payments out from different type of pension funds, etc. So maybe people might want to take legal advice on some of those issues, but we don't require it. And for the vast majority of people, they should be able to get through the process without it. But if people think they feel they need it, that's a decision for them.
Perfect. And just one more here. Is it always more financially beneficial for the customer to apply for Fair Deal instead of paying from their own assets?
I mean, I think that's a simple question. I mean, if you apply and we say we're going to pay, your client contribution is €1,000, but we'll pay the rest. Like, why wouldn't you get the state support rather than paying the amount yourself? If your client contribution is less than the cost of care at the nursing home, the state is paying something on your behalf. So I'm not sure why you wouldn't apply for that.
How many fair deal arrangements within the 3-year farm cap are out there at the minute? Do you know?
Oh, I should know, and I'm not going to give you a figure off the top of my head. Sorry. I'm not willing to give you a figure. Like we're in the very low hundreds.
Is the ancillary support scheme the same amount as paying weekly over the 3 years?
With the exception that, I mean, the person has barred the 3-year, the CPI at the end. Yes, exactly. So if the value of the principal residence, if we're calculating that as €200 per week, either you pay the €200 or we pay €200 ASS on your behalf. So the answer is yes, bar the CPI.
We might just take 1 or 2 more questions. Just if a person has signed over their home 6 years before the application, but has retained a right of residence in the principal private residence, how is that assessed?
So there's right of residence or life interest. They're 2 separate legal things. A right of residence we dismiss, we don't include. A life interest is included because that has a value, and the revenue commissioners have a sliding scale of the value of a life interest in a property on the basis of your age. And we use that sliding scale to calculate. So again, they're 2 distinct legal issues. We need to see the paperwork to see which one it is. Both right of residency, there's no charge. Life interest has it's a more secure arrangement, and it has a value as far as revenue is concerned, so we do include it.
Okay, we'll finish up with 1 more maybe, Olsen. I know we've kind of ran over time. If a brother and sister is living together, will they be treated as a couple when applying for the fair deal?
No, they're assessed separately, not as a couple. But again, if they own the house 50%, we're only including 50% of the value of the property in the assessment. Charge is 7.5%, but it's only half the value of the assessment of the full value. We're assessing half the full value of the property. Sorry, somebody said, could you repeat right of residence? So there's a distinction between right of residence and life interest. In law, there's a very clear distinction. If the arrangement is a right of residence, there's no charge on that in fair deal. If it's a life interest, there is, because revenue put a value on a life interest, and we use the sliding scale. It's available on the revenue website. It's actually based on your age, and the older you are, obviously, the less benefit you're going to get from it on that sliding scale.
Okay, Alton, thank you very much. We'll leave it there at that. There's lots more questions there, but we'll have a recording of this up on the website in the coming days, so people can go back and get the questions and answers again. So I'll just hand you back over to Teresa there to conclude the meeting.
Thank you, Alton Hines, for a fantastic, informative presentation there on Fair Deal. And I hope to all our guests online, you've got a huge amount of information that was mind-boggling, I'm sure, for many. But I think if it's been very clear and concise, has been from Alton, who's given us great practical information that we can take away. I suppose for me, I think some of the words I'd like to reiterate from Alton, what he's explained, some of the important things is to make sure you've handed over your farm for at least 5 years prior to actively accessing fair deal. And then the other one is to appoint a successor and who will actively farm the land for 6 years after you enter the nursing home scheme. I think, and then I think one I did learn about there tonight was the life interest, which has a charge, and the a right of residence has no charge. That's something I wasn't aware of, and that sliding scale. And I suppose, we all, for many farms, it is, we want to maintain people farming, we want to keep people living in rural Ireland, and we want to maintain, the generational of farms in families, and to, for generation renewal as well. We want to make sure that that is there. So do get legal advice, do get your accountant on board, and do get tax advice as well. And if we're here as an organization as well to support you, and Claire and I and our committee, which we have a representative in each county, is here to take any of your questions. And this webinar is also available online for you to replay. And if you have any further questions as needed, please get in contact and we'd be happy to support you. But for tonight, I just want to say thank you to Ultan Heinz for your wonderful presentation, and I'm sure it'll be open to more discussions again. And thanks to Claire Madeleine, much appreciated.